not a planning function. It is not a discretionary function. It's an operational function. And in this case, the discipline involved students in one group during a group learning activity harassing another student. And the teacher had a duty on each occasion. It happened at a 45-minute classroom period, twice before the third incident. This group learning activity, the students were allowed to form their own groups and scoot their desks together. The teacher stood at the podium at the front of the classroom and would give out the math problem. The teams then worked in a competition to come to the correct answer, and each team designated one person then to take the test, their answers, to the teacher at the front of the podium. So in other words, it was a competition, and whoever got the first answer got points, and it involved what we call a foot race in a classroom. Okay, the problem is one group of students was harassing the student of another group who was delivering his answers. And they would do it by blocking his path, and they did it by hitting his body, and he was becoming frustrated. And this occurred twice in the beginning and middle of a 45-minute classroom period. Each time the teacher observed it, each time the teacher said something, but each time the teacher failed to take appropriate discipline. And had the teacher taken appropriate discipline on the first, and then on the second, the third would never have occurred. So we have a but for.
Do the policies prescribe the discipline that must be taken after 2 incidents of harassment, or does it offer a range, or what do the policies require?
Well, first it says swift and severe discipline, and then there's a range of discipline. Then we raise another issue here too of what is the professional standard of a teacher, and we presented an expert who presented other teaching modalities that were available to have corrected.
Counsel, do we apply a professional standard with regard to teachers, or is this a matter of ordinary negligence assessment?
Well, we have a legislature who passed statutes in the early 2000s that started identifying teachers as professionals. And we have statutes that say that the teacher as a professional, that they have a duty to protect students, and particularly anti-bullying. And we believe that this meets the definition of bullying. Physical, unwelcome touching of the body. And this student each time expressed his frustration. And each time the teacher failed to take the appropriate means. The appropriate means could have been simple as this. Student, you will no longer deliver your answers. Group, you will move over. We will change the way. You can raise your hand instead of delivering. There were so many opportunities that were available to the teacher as a teaching modality that she didn't do. She merely gave a verbal warning each time. On the third incident, the same student, same type of assaults, frustrated, retaliated.
So how is it foreseeable that a third party gets injured through an object being thrown? I mean, maybe it's foreseeable there's going to be some kind of physical altercation between these students, that there's going to be pushing and shoving, and how do we get to foreseeability of the plaintiff in this case being injured?
Well, the foreseeability doesn't have to be the exact mechanism of injury, but is it foreseeable that there would be retaliation? Now, what could have been thrown? Punches, kicks, or an object in retaliation? That's foreseeable. The teacher watched this. After the fact, the teacher made a confession saying, I should have seen it coming. Now, the fact that the pencil was thrown, we can't focus on that. The question is, why was he frustrated and retaliating? Why, and is it foreseeable then if a student who's being harassed and provoked into a fight, and the rules say the teacher has a duty to stop this, to protect not just the bullied student, but all students, isn't it foreseeable then that innocent bystanding students will get injured in an altercation? Now, can we predict exactly how a fight's going to happen? No. But we can predict if provoked 3 different times in 2 prior occasions, the student showed his frustration and his anger, that some type of a response is foreseeable. Now,
in terms of the interactions here, the verbal directions from the teacher, reprimand, whatever we're calling them, they seem to have curtailed the conduct, right? And you have the students, she says, stop moving your desks. She says, don't, put your arm in front of, and the students cease. And doesn't that undermine your foreseeability argument that the students, my understanding is, and correct me if I'm wrong, that we have these two incidents where the chair gets moved in front of the student, the arm gets placed in front of the student, then we go about a half hour where really nothing seems to be happening, and then we have a third incident and the student retaliates at that point. And doesn't the response here reduce the foreseeability of this action in terms of the students, they stop putting their arm in front of them, they stop moving their desk in front of them?
No, because the response was inadequate. And if you looked at the plaintiff's expert, she says so. And the rules and the duties, the pre-existing rules and duties said intervene and to stop it because it's bullying. And we had a public policy set by the legislature. We have statutes that say this. We have pre-existing regulations of the teacher in the Montgomery County school system. We have the student code of conduct, and we have the teacher's code of conduct, all of which required immediate intervention on the first one. And had she done it properly, the second would not have occurred. Well, the second one occurred. Well, didn't she act right on that? Well, why did the third one occur? 2 prior instances. Third one is a strikeout. More importantly, she had a pre-existing duty to act, to intervene. Legislature, not just regulations, but the legislature passed laws. Now, the laws shifted several times on the different, and we cited it in the brief at different times, but at all times standing there was some statute that said professional anti-bullying. And that was the duty. That's the legal duty pre-existing. And 2 prior opportunities, 2 times, had the teacher done her pre-existing duty, according to our expert, it would not have occurred again. Problem we're here for, though, is the trial court, in applying summary judgment, didn't follow the law. Must take all facts in the light most favorable to the non-moving party, and all inferences must be drawn for them. These facts are in the record. The judge didn't address them. We asked that you...
Counsel, you said that facts weren't addressed here, but the prior incidents here do not involve the plaintiff in terms of this aggression, and in terms of how the trial judge is describing the ruling in this case, isn't she essentially, she's not mentioning those prior altercations or incidents, but they didn't involve the plaintiff, and I'm a bit lost there. And why was that an errant description or failure to read the facts in light most favorable to the plaintiff?
Well, the duty of the teacher was to all students, and the prevention of the bullying was not just for the person who's going to be bullied, but the entire educational process. And she has a duty not just to the students, but to protect the classroom safety, which is everybody. Her duty is greater.
With regard to the teacher's statement, question's been raised with regard to the admissibility of that statement. Does that matter in terms of the summary judgment? Let's say it is an admissible statement. How does that play out in terms of summary judgment analysis?
Well, for summary judgment, once again, I'd say that all facts should be construed in the light most favorable to the plaintiff, and any inferences should be taken that way. Now, if we're going to be arguing about evidentiary issues, that's part of the problem we have here. We didn't have any evidence. There was no hearing. There was no proof. There was no finding of fact. As a matter of fact, we asked the court to make some findings of fact and to correct, do whatever. And the court just dismissed. Which kind of makes it hard on this appeal, except for them to come and say, we have a prima facie case, and let me just make the prima facie case for you and show you that the judge didn't apply Rule 56 properly. Is there any other questions?
See none.
Thank you.
Good morning, Your Honors. I'm Mark Nolan. I represent Clarksville Montgomery County School System, along with my partner, Jeff Goodson. And I'd also like to introduce Haley Crawford. She's a new attorney to the bar, and so this is her first viewing of a Court of Appeals argument in the live. So I want to point out several things to the court. There's a lot of material to cover. We may not get to it all. But the court had 2 vehicles, 2 avenues to go down to dismiss this case. One is under the Tennessee Governmental Tort Liability Act. because this is a governmental entity, so the GTLA applies here. And then two, as what the court did write the opinion was that this wasn't reasonably foreseeable, and that's what the opinion was. And so this court can affirm the decision on anything that's in the record. And so the Tennessee Governmental Tort Liability Act, the school system comes in to this case immune. We don't have to do anything to prove it. That's just the way the law is. There are exceptions as when a community can be removed, and this is 292205. Immunity from suit, an injury approximately caused by a negligent act by an employee. Ms. Berg is an employee. She's not a defendant, but she's an employee. Acting within the scope of employment, she was. So a negligent act removes immunity except, number one, the exercise or performance of a failure or the exercise or performance or the failure to exercise or perform a discretionary function, whether or not the discretion is abused. And so you just heard Mr. Olson say, well, this wasn't a discretionary function, student code of conduct, now, implying the student code of conduct. Of course, the student code of conduct controls not teachers, but controls the behavior of students. And there are certain things that the legislature have said that are mandatory, such as if you come to school with a weapon, you're going to be suspended for a year. There are some mandatory things. This is not in that category. So you look at cases to determine, is a teacher applying a student code of conduct a discretionary function or not? And the cases say, yes, that is. So I want to turn the court to well, Bowers versus City of Chattanooga, which is the main case we cite in there. But I think the case that is illustrative of these two things is Riddle versus Lawrence County, a 1989 case. And this was a case where a minor child was injured at a recess activity. The kids were in a circle, and you had to drop a handkerchief and then run around the circle. That was part of the game. These are younger kids. And so the teacher had told them, don't run through the circle. And so the child was running through the circle, and he injures another student. And this happens about 3 different times as far as the discipline. So the first time the teacher says, hey, let me remind you, don't run through the circle. The second time, student, you sit out, and he stays in the game, and he does it a third time, and the student gets injured. The court in that case said that where a teacher is present and reasonably exercising discretion in the control of students at the time the student suffers a personal injury, the exemption of discretionary acts applies. 292201. So discipline is a discretionary function because for those classroom teachers who are on the front lines every day, there's no doubt, they're the most likely to see what it is.
So, counsel, under your reading, if a teacher is present, it's impossible to pursue a liability action based upon negligence, it sounds like. I mean, any decision that a teacher makes, whatever the decision they make, is a discretionary decision. And is that a correct reading of how the statute's supposed to operate here?
Certainly in this case.
Well, I mean, what's the limitation under the understanding you're suggesting? And what decision could a teacher possibly make in terms of controlling a classroom? If it's a discretionary decision, how you discipline a student in the classroom, what action you take, is there any outer boundary? I mean, can you give me an outer boundary on that, or is there none?
I can't, because of the Riddle case and then Babb versus Hamilton County case, which we also cite in the brief, both talk about discipline, and when the discipline was questioned, the court in both of those cases said this exception to the GTLA applies and immunity is not removed. So I am here by this table that's 100 yards long. Now, just because I say it's 100 yards long, does that make it true? In the brief of the plaintiff. They talk about assault, they talk about bullying, but we know that this court has put forth like Tennessee pattern and jury instructions, and we would instruct the jury, you hear the case, but you don't have to throw out your common sense. It's not common sense that this is 100 yards long. And so when you look at the facts of the case, what happened in that classroom at the beginning of this activity? One student scoots his chair back to attempt to block him, and the teacher sees it and corrects it. Don't scoot your chair back. And the next time when Mr. McCrae comes up, somebody puts their arm out to try to block him. That's not assault, and it's not bullying.
Why isn't it bullying? And you've got a student who's participating in a classroom activity that you have another student block them from being able to participate, pull their chair out in front of them, put their arm in front of them. Why isn't that bullying?
Even if it is, the teacher addresses it. And so you've got different students that did that in those first 2 rounds. And so the teacher doesn't ignore it. The first time she sees it and calls it out. The second time, Mr. McCrae goes up and gives her the paper and says, he held his arm out and tried to block me. And she addresses it. So the teacher doesn't ignore it.
Judge McCrae, I believe, earlier was asking about the sort of policies with regard to discipline. Is there any set policy here that says, and there's an immediate response, prompt response, something to that effect, but that says a verbal warning or directive is insufficient? Is there anything that would say a verbal warning is sufficient? I mean, do we have that kind of clarity in the Montgomery County policies or not?
No, it is not that exact, because again, we are giving teachers discretion to make that call based upon what they see. And you're right, there are offenses that are going to require a higher level of punishment. But remember, the student code of conduct is written for the students. The teachers may just be the ones that see it and report it, whether they address that classroom behavior on their own or they send it to the office to address it that results in some other level of punishment. All of those are discretionary functions. So when I say the first way we could address this is that the government is immune for those type of decisions, because the policy doesn't require her, well, the first time you see somebody just to kind of put their arm out, we're going to instantly think on that is now harassment or bullying, which is a lot of times a pattern of behavior.
Is this a professional standard now in Tennessee, or is this still a matter of ordinary negligence? And so there's an expert here who essentially says, well, I wouldn't have done it that way, and if you didn't do it that way, then the student wouldn't have gotten injured. And are we looking at ordinary negligence, or are we looking at a professional standard?
There's no higher standard. The legislature did not create, just because we say that teachers are professionals doesn't create a higher standard for them. And interestingly, the discretionary function, which the expert did criticize, was the classroom control about how to run this learning activity. You could have had them raise your hand. You could have had them use a whiteboard. Those, again, are based upon the discretion of the teacher to run this learning activity, and so discretionary immunity applies also. Now, of course, as in the last case you just heard, and we know that the court foreseeability of this is key. Is it foreseeable that something like this throwing of pencil is going to happen because those other incidents happened? Now, that was at the first of the classroom. Almost 30 minutes goes by, 15 more rounds without problems. They had no problems earlier in the day in the first 2 periods running this activity. There was no history of problems with these students. In fact, Mr. Hurt, one of the other defendants, was new to the school. He really didn't even know the people in the class. So there's no way that the teacher should have thought, okay, well, because those first incidents happened, and I addressed them as in don't do it, that now when Mr. McCrae comes up here at the end of the class and he hands her the answer, this time he's going to turn and throw a pencil.
Counsel, in your brief, you noted that things weren't being thrown, essentially. There was no throwing action. How close does the fit have to be? And here, opposing counsel says, well, essentially it was foreseeable that you could have punches thrown, you could have sort of some kind of violence, aggressive action between these students. And does it have to be as specific as foreseeable that something was going to be physically thrown, or is it enough that it was foreseeable that there was going to be some kind of aggressive exchange between these students?
Well, nothing that had happened before would indicate that there was going to be a level of an aggressive exchange.
I understand you're not conceding that that's shown, but in terms of, let's say we disagree with you on that, and we think there's enough here to think there's going to be something that happens between these students. How precise does it have to be? I mean, I noticed your brief, you referenced a number of times, nothing had been thrown. Does it have to be that specific, or is it enough, if we get over that hurdle, to have the idea that there was going to be some kind of aggression between these students?
Right. So the three cases that I think are relevant and illustrative of this are Roberts versus Robertson County. It's a 1985 case. It says several different things. Teachers and local school districts are not expected to be insurers of the safety of students while they're at school. They are required to exercise such ordinary and reasonable care as prudent persons would exercise under the same or similar circumstances. And I think responsive to your question, with specific reference to the conduct of teachers, we do not impose them upon the duty to anticipate or foresee the hundreds of unexpected student acts that can occur on a daily basis in our public schools. It's in 1985. 20 years later, Mason versus Metro Government follows up. And so, yes, the law has changed and evolved in that time. And so Mason and then Hopper versus Obion County are two cases that says, although society places significant responsibility on school officials to provide a safe environment for our children and the students, however, such responsibility does not make our school officials insurers of their safety. And to the contrary, teachers are not expected to be insurers in the safety of all students. So there's nothing that would indicate to Ms. Berg that should have put her on notice that that addressing the two incidents before, which involved a different student than Mr. Hurt, who was one of the other defendants, is going to result in Mr. McCrae throwing a pencil. See, when Mr. McCrae, who was the one that was delivering the answer each time he came to the classroom, he knew from his own, if he addressed to Miss Berg, hey, they're trying to block me, she would address it, because he's already come up and told her on the second time. So the message to him was, if something's going on, tell me and I will address it. He didn't. He didn't say a word to her on that third time. He just turned and threw a pencil. And so there's no way that she should be on notice or foresee that that pencil is going to be
Counsel,
thrown.
what do we make of her statement, though, that seems to suggest to the contrary, her communication with the family, where she essentially seems to say, I should have realized this was going to happen, and I deal with teenagers, have teenagers, and isn't that communication problematic here for your position?
It isn't, and I know my time is limited. You look at a record of page 18 and 19, which were part of the depositions where she was asked about that, where she was explaining that. She said there was no indication to me to understand that that was what was occurring. I didn't have control over it because there was nothing to indicate to me, based upon what I saw, that there was anything wrong. So she's explaining that, and I will make one other analogy. That's also a legal conclusion versus a factual conclusion. She's an employee. What if she had written the email to the parent and said, I didn't see anything and we didn't do anything wrong, and I came in here with that motion for summary judgment and that fact, you wouldn't let me use that email for that legal conclusion. If that's the case, I'm gonna put a policy out to all the teachers. You always write something self-serving that says we're never at fault. But that's not how it works. That's a legal conclusion for the court to decide. I'm out of time, sorry.
Thank you.
Just three things that were discussed I'd like to rebut. First, the duty. If you look at TCA 49.6.4503A, it says that school districts shall include policies, and then it also discusses zero tolerance for bullying. And at TCA 49-6-4216 parentheses B parentheses 1 states there be zero tolerance policies concerning a safe learning environment, mandates violators receive certain swift and reasoned punishment. A teacher must enforce discipline upon observing a zero tolerance offense. Seems like a duty. And it gets into when it talks about a safe learning environment. We know.
Why does that mean that the teacher, or what would you point to suggest that means that it's insufficient for the teacher to give a verbal correction? And the teacher here, there's a student who pulls his chair in front, teacher says, don't do that. And it seems to stop the students from doing that. The students then come up with, as students may, come up with another way of blocking the guy. They put out an arm instead of moving a chair. Teacher says, don't do that. And it seems to stop.
It doesn't, though. It doesn't, because it occurs again. And more importantly, though,
well, that activity didn't. The throwing of the mechanical pencil seems to be like a totally unexpected. Don't know what even the right word to use for that escalation in the conduct, from an arm bar to a shoved desk to the throwing of a mechanical pencil, and not only just a throwing, but a mechanical pencil that bounces on a hard surface.
No doubt about it. It was a lucky shot or unlucky shot, however you want to put it. But that's the foreseeability of the retaliation. The exact manner in which he is going to retaliate is not going to be foreseeable in the many ways it might be in a fight. But if after 3 times, and the first 2 times he did express his frustration and his anger, it continues. But once again, it gets to the duties that were passed by the statutes and the regulations, and that the teacher then had a duty to do more than just a mere verbal warning. And this gets into
after each instance, does the record here show that the student, I'm using your characterization, not necessarily suggesting the court agrees with this, but assuming for the sake of argument that this is harassment or bullying, the bullied student here, harassed student here, did the record show that he exhibited anger after each of these incidents?
Yes.
Okay.
And for this purpose is for summary judgment, right? As far as on a summary judgment ruling, all inferences should be taken, and there is evidence of that in the record. They also can argue and say that opposite, right? But that's not for summary judgment. We got to look at the facts that are there solely for the plaintiff, for the non-moving party. Remember this too. We have duties to protect third parties when we have foreseeable situations, and that's the duty to protect the innocent student here. Right? The classroom safety is the teacher's duty, not just the bullied student, but the entire classroom environment is the teacher's duty. It's foreseeable then, if something continues to go out of line, somebody else might get hurt in some fashion that I don't know what it's going to be, but I know this as a teacher. If I stop it now, it won't happen, whatever it might be, and that's our case. Thank you.
Thank you. Thank you, counsel. We'll take this matter under advisement, review the record, and we'll attempt to get you an opinion at the earliest possible time. You may be excused. Ms. Ashley, we're going to take a brief recess. I want Nick to check something on the microphone.